So, good evening, ladies and gentlemen. I am Mahir Sood, your moderator for today's special event, and I have the privilege of welcoming you on behalf of Vidhi Talks, which is a prestigious initiative by the Bar Council of Punjab and Haryana at Chandigarh. Vidhi Talks is a platform that brings together legal minds, academics, and practitioners to reflect on transformative ideas and evolving legal landscapes. Today, we are gathered for a virtual book discussion on an exceptional and timely publication titled as Practitioner's Guide to International Family Law, an Indian Perspective, authored by the distinguished father son duo, Mr. Ankit Malhotra and Mr. Anil Malhotra. This works serves as a remarkable guide to the intricate world of international family law from an Indian context. This book is not only academic in its structure, but extremely practical in application, ladies and gentlemen, especially for the legal practitioners dealing with the cross border matrimonial, custody, surrogacy, and the property issues. We are honored here today by the presence of several eminent legal personalities and luminaries from the legal and administrative world who have kindly agreed to join this discussion. And allow me to introduce them through our co-author, Mr. Ankit Malhotra, who will wish a warm welcome to our esteemed panelists here today and introduce our guests of honor, please. Over to you, Mr. Malhotra.
My Lord Justice Sikri, ladies and gentlemen, it is my joyous honor to extend to each one of you a warm welcome as we assemble for this virtual discussion marking the launch of the Practitioner's Guide to International Family Law, an Indian Perspective. Think of this guide not as just a dusty tome, but as a flickering lamp held in the dark corridors, as its steady glow revealing the tangled paths of cross-border unions, intricate custody battles, and the knotty riddles of surrogacy, guiding today's families through their most trying and darkest hours. Now, knowing that I have time limited, I would also like to make this welcome address also a thank you address, and therefore I begin by thanking my father for his decades-long devotion to legal scholarship and also to the profession, both academically and also through his work. From the very foundation of this endeavor, this was his doing and his craft and his personality. He has been, in every respect, the Krishna to my Arjun, sharing wisdom, guiding me through ethical quandaries, and interjecting with wisdom of the sages. If I were to bring even a fraction of this insight, tempered by my fondness for his well-timed anecdote, then our readers will be able to discover not merely a manual, but an epic of legal exploration. I am also equally privileged to present our esteemed guest, His Honorable Lordship Justice A.K. Sikri, an exemplar of judicial restraint in his luminous judgments, navigates the perils of overreach alongside the court's natural causation with enviable dexterity. If family law today resembles the Ganga in full monsoon, Justice Sikri's wisdom serves as our steadfast guard, ensuring that we may embark and disembark safely. His pronouncements on, say, for instance, the parental alienation syndrome and the sanctity of constitutional remedies have profoundly reshaped our understanding of familial bonds under the Indian sky. Permit me also to pay homage to senior advocate R.S. Chima, whose submissions, crafted with precision of a sitar virtuoso, have for decades underscored the primacy of fundamental rights in our constitutional tapestry. We must not forget Professor Emeritus Professor Balram Gupta, whose academic journey through our legal theory studies has been nothing short of a pilgrimage. Furthermore, I am delighted to welcome Smrnali Deshmukh, whose mastery over family law stands akin to the finest lawyer who has been known to man. The fluidity in expression and the transformation it has is undeniably profound. Finally, and by no means last, Mr. Rameshnder Singh, a Padma Shri, perhaps higher than an MBE, as was said earlier, recipient and former Chief Information Commissioner, whose lifelong dedication to transparency reminds us that in family law, secrecy often bounds itself as the greatest adversary. We gather here at this moment when tradition and transformation move together, sometimes harmoniously, sometimes unevenly. On one hand, our cherished Indian familial roots, rooted in generations of households, and the sky blue statue of Thiruvalluvar, the revered poet and philosopher whose statue rests serenely outside SOAS, a place which I should return to later in this address. He once observed, "A home where virtues reside is a true home," compels us to honor parental duty, community bonds, and most of all, the sanctity of a union. On the other hand, on globalization, which has arrived like the first monsoon clouds, expanding our legal horizons to encompass international conventions on child border abduction, surrogacy regulations, and the rights of citizens and non citizens alike. Our guide, as our readers will soon come to realize, rejects the notions of static dogma. It is instead a living compass, directing us towards resonating debate, compassionate adjudication, and an unwavering respect for human dignity. Let us be clear, nonetheless, every enactment of law, every scholarly footnote, and every interpretive nuance ultimately affects fathers, mothers, sons, and daughters, whether in Mumbai, in Manchester, or even Mumbai upon Thames. No family should find itself adrift, bereft of recourse or understanding, when the tides of legal complexity threaten to overwhelm. Before I conclude, I must also extend a special invitation of thank you to my uncle, Advocate Ranjit Malhotra. As the first Indian lawyer to receive the prestigious Felix Scholarship for his LLM in SOAS in 1993, he has been a long-standing member of IAFL, IBA, and AILA, and numerous other international bodies, and his contributions to family law from authoring the first 9 books with my father and also presenting his paper at Harvard Law School just a little over a decade ago. His work has been meticulous, and so I offer him an unwavering thank you for his dedication, his professionalism, and a testimony to the work that he has done for championing the cause of knowledge in international family law. Thank you. Staying with the theme of family, I would also like to express my deepest gratitude to my mother and also to my sister and the entire extended family, whose unwavering love, encouragement, and steadfast support have been my guiding light through this journey. I would also like to acknowledge our publishers, Vikesh and Srish, who have offered their utmost, and I am to them grateful. In closing, I also extend a heartfelt note of gratitude to the conveners of the session who've tirelessly worked and brought this to fruition. With that, I urge you to engage in today's discussion and proceedings with both vigor and generosity in spirit. Let our discussion emerge from fresh wells of insight, unafraid to chart new tributaries in family law while remaining anchored to the bedrock of constitutional mandates. Welcome, everyone.
Thank you. Thank you so much, Mr. Ankit. That was a very warm and wonderful welcome. And let us now we begin our chair for the evening, Justice A.K. Sikri, the Honorable Judge of International Commercial Court of Singapore, and of course, the former Judge of the Honorable Supreme Court of India, Justice Sikri, the mentor of the authors, a celebrated counsel of all seasons at the bar, is an eminent jurist, a former judge of the Honorable Supreme Court of India, and has been the Chief Justice of the Punjab and Haryana High Court at Chandigarh. Eminently renowned worldwide, academically and professionally, his humility is at par excellence. Ladies and gentlemen, presently he is the international judge at the Singapore International Commercial Courts, SICC, Singapore Supreme Court, and chairperson of the News Broadcasting Standards Authority. Justice Sikri has authored over 4,700 reported judgments, dear legal fraternity members, and you'll be astonished to know that all these judgments are on various different fields of law. He was chosen as one of the 50 most influential persons in the world who impacted the growth of intellectual property laws for the year 2007 by the MIPA. He has written scholarly articles in various journals and presented learned papers in various national and international conferences. He has several articles in the field of human rights, commercial laws, arbitration, and mediation. And with his esteemed presence and with his experience on the legal side, it is a great honor, sir, to invite you, Honorable Justice A.K. Sikri, for the opening address, please. Over to you, sir.
Thank you very much, though, and for your kind words, though that was not essential in today's ceremony, particularly when we are celebrating the work, this, I would say, stupendous and magnificent work of the co-authors, Mr. Anil Malhotra and Mr. Ankit Malhotra. So it is these two persons, along with their extending the arm, Mr. Ranjit Malhotra, who need all accolades and for their, I would say, not only as far as this book is concerned, insofar as their contribution in the field of family law is concerned, whether it is domestic law or international law, and various other facets, because it is not their first book. Maybe it is 10th, 12th, or 15th book. I have lost the counts by now as to how many books they have written on the subject of family law. And so today, this launch, I would say, is the celebration of this event and celebration of the two authors on what they have given to the society, not only Indian society or Indians, but across the world. Because although the book title of the book is Practitioner's Guide to International Family Law. So it is the facets of international family law and from an Indian perspective. So for any practitioner, as the title itself suggests, and I mean, I may also say that yes, here I'm giving a verdict that it is truly and indeed a magnificent and a very helpful guide for all practitioners in the field of international family law. And let us, I mean, before I come to what the book is all about, and I would not take much time because there's so many speakers, and but how family law becomes important in any society, because the family itself, the concept of family, and which started from time immemorial, and we know that the families play a vital role in shaping individuals and society as a whole. And some of their contribution, if we say social and values, are there. They shape values and beliefs, instill values, norms, and beliefs in individuals, influencing their worldview and behavior, socializations that they teach children social skills, etiquette, and culture tradition. There's an emotional support and well-being in family. There's an economic and social stability. There's a culture preservation and transmission, and there's a community building and social capital. So all that is because of the family as institution. And family as institution starts from the institution of marriage. And as we know, therefore, institution of marriage is a pillar of human civilization, encompasses which encompasses tremendous emotional and cultural importance that goes beyond the simple legal and social commitments. Why I'm saying so and why I'm emphasizing is that it is this, I mean, the social fabric in a family which contributes to which rather is the basic or foundation of the formation of any civil society or any nation. So that is the importance which is to be given to the families. And yes, over a period of time, various laws have come up in respect of various facets of these, I mean, families, as we know. And this shows the significance of knowing these laws and implementing and enforcing those laws for the betterment of the society. Because once these laws are properly administered and justice is given within the members of the family, if there are disputes of various nature, that has their effect and cascading effect on how the society would function or how the society would behave in a particular nation. So therefore, that's the importance which we have to give. As we know, when we talk of family, law, and which is the topic here, and those all those topics are very well covered. This marriage or matrimonial relationship between the husband and wife, that becomes the first and foremost aspect of any family law. Then depending upon what kind of families we have nucleus families, we have joint families, etc. Depending on that, there may be various other kinds of law, like in India, because joint family, so we had our Hindu law relating to succession, etc. But law of succession, in any case, is another facet and aspect as to how the properties, etc., of a family is to be ultimately transferred to the next generation or in succession. Then this is a bearing of children, because that's the main fundamental, as we have seen, and as the societies or the recognize, is that to bearing of children. So then the laws around their children also that they come into play, particularly if there is a dispute between husband and wife, the custody of children, the rights of children, because which have been taking shape from time to time in different respects. And then if there, there are matrimonial disputes, then the issues relating to divorce, issues relating to maintenance, issues relating to alimony, and again, as I said, succession. But along with that, we have the issues of or the aspects of adoption and guardianship, etc. Also, all these issues are related to family, and many other issues are related to family law. And yes, each society in each country, because they have a different cultural backgrounds and their societies have come up in a different way altogether. And the as I would tell during the course of my today's discussion, that many mythologies or mythological stories in different cultures which have come up, whether it is India or it is Greek mythology, etc., how they have influenced the family laws or the development of family laws, and how we can find some of the answers by looking into those mythological stories. That is actually why I'm saying so. This is one of the unique and extraordinary feature of this book, and I'm really amazed how Malhotra's saw that those mythological stories can be so relevant in order to understand the various nuances and facets of the family law. But then what I'm trying to say is that, look, these are the aspects, and within, as I said, that in different countries they have different kind of their cultural system, and which influence the family ties up, etc. And therefore there may be different laws altogether. But today, it's not that the a particular family law or the facets of family law, they work within the the sphere of those geographical or national boundaries, because today they have transcended and they are cross-border ramifications because of globalization and liberalization of economies. And with the globalization, as India also ushered into the era of globalization way back in 1991, there's a lot of foreign investment in India and Indian investment outside. And it is not only the investment in the form of capital, but there is a lot of human movement also, the workforce movement also across the countries from one country to other, which has in a way brought about in last 40, 50 years or even more a totally different kind of cultural revolutions, if I may say so, or transformation, if I may say so, in various countries. Today, a position is that suppose that an Indian who has, say, suppose gone to America, he may marry there, he may marry an Indian girl who goes there, he may even marry another girl from another nationality who is also settled in America. Suppose a German girl who is settled in America and an Indian boy, they get married there. Now, and if their family issues arise out of those marriage and which have legal complications, so which law would apply? It is Lex Loci, Lex Fori, all those, in international law, private international law, these are some of the aspects which we have been reading from time to time. But today, their dimensions, their nature of, complexities, etc., they have totally changed in because of this. Now, how the assets created there would be distributed if there is a dispute, how the children insofar as the custody of children is concerned, how that has to be governed and that has to be seen. As we know, and these authors have already earlier written, Mr. Malhotra and Mr. Ranjit Malhotra have co-authored books on this Hague Convention, the what we call the parental abduction of a child, that suppose that child custody is given to one parent in America, but the other parent brings that child to India. And then how these issues are to be resolved. Hague Convention is there, but India so far has not been a signatory to it, has not signed the Hague Convention. So in the absence of Hague Convention, how these laws would be applied? If a decree is passed in respect of any of these aspects in a foreign country, but then it is to be enforced in India, what kind of laws would be applied? In the absence of, we have, yes, Section 13 of the Code of Civil Procedure, which discusses about the enforcement of foreign decrees. But then we know that in order to enforce that decree, there are certain conditions to be satisfied. That is one of the examples I'm giving. So one of this is that the decree should not be apart from, it should not be obtained by fraud. It should be, there should not be violation of principles of natural justice. But the main aspect, other aspect is it should not be opposed to public policy of India. So therefore, a decree, suppose a divorce is taken, ex-parte divorce is taken by a husband there, but then whether our laws, if both are Hindus and under Hindu Marriage Act applies, if that such a case had to come to India, whether on the grounds on which divorce is granted by the foreign court, whether that would be admissible in India or not. Likewise, as I was saying, as far as custody of child is concerned, we know that in India, we have this principle that the welfare of child is the paramount consideration. So whether that has been taken into consideration, this is very easy to say. But when the actual cases come, the problems they raise, it is not easy to settle those problems. And I must say that, yes, in one sentence, notwithstanding the absence of some statutory regime in India in respect of these provisions, the Supreme Court, High Courts and Supreme Court have come out with various methodology to still to enforce that, including some of the fundamentals or underlying principles of Hague Convention in certain cases. And when I'm saying all this, I'm not saying that, yes, these are the problems. What I'm trying to say is that here is a book authored by Mr. Anil Malhotra and Mr. Ankit Malhotra, mentioning about all these facets and how these the such problems which may be of international family law, how these are looked into by Indian courts from Indian perspective, and how these are dealt with. That is what is the beauty of this book. And there are certain unique features of this book which are not only I may say innovations, or I may say the application of these principles which are thought by the authors for the first time in a unique way, not hitherto considered by any book, by any author, by any article. So that is where this book makes all these aspects unique. First is, as I've said, that look, this is seen from the prism of, they start with the mythology. And so the book effectively sets up the stage for a deeper exploration of how international family law, particularly from an Indian this perspective, navigates similar challenges today. That is a very, very unique feature. Then how family law issues shaping up at international level. This is again a very interesting treatment which is given in this book and which I have seen. Then what kind of issues are arising internationally? And the authors have dealt with some of these chapters. If you see from the chapterization of the book itself, uh, and just to give a perspective, they talk about the marriage, divorce, and ancillary relief. They talk about the issues related to children, which I have mentioned. They talk about maintenance, alimony, and family settlements. They talk about citizenship, passport and nationality laws. They talk about, in particular, the laws which are applicable in Goa, Dadra, Nagar Haveli, and Daman and Diu because of the foreign rulers there and how they brought the laws, even the family laws in those states, and the law applicable for Muslims. Then they discuss about the Indian laws of domicile, wills, and succession as well. And what are the another unique feature is what are the remedies which are available for foreign nationals. Even that is one of the chapter which is contributed here. Apart from the chapter on surrogacy, which again is becoming more and more relevant over a period of time. So I, at the end, say that I really congratulate Anil and Ankit for producing this wonderful work, which is going to be, I mean, the work, it is going to be recognized not only in India, but all over the world. And this book is needed by every person who, every professional who is doing work in family law. I have always been amazing. That's the last thing which I would say. I was always amazed as far as contribution of, I would say, Punjab or Chandigarh High Court and the state of Punjab is concerned. It is known for development of law as far as criminal law is concerned. It has produced best lawyers in criminal law, as we know, and it was said much earlier during British time that main cause of crimes in India is Jad Joru Jameen. So these are the factors which are prevalent in Punjab. Therefore, Punjab, there has been because of these reasons, if there have been crimes and there have been serious crimes also, but then it has given rise to best of the lawyers who have been and best of the judges in Punjab and Haryana High Court who have been able to develop a really outstanding kind of jurisprudence. Same thing applies to service law. That is the second thing which service law again, it is, most of the cases in service law that they originate from this Punjab and Haryana High Court. So their service jurisprudence, which is ultimately taken up in the Supreme Court also, that the contribution in service law has been tremendous. And now I find that this Punjab and Haryana High Court with lawyers like Malhotras can take pride in this, that we are shaping the family laws in this country by our contribution, not only fighting cases day in and day out in the court, which have international ramifications, and but writing these books without any break, one after the other. I don't know how they are able to find so much of time, not only in, they are so busy lawyers in the practice, but at the same time, they find times to produce such wonderful books, which is in a way a service to the society. Thank you very much.
Well, thank you so much, sir, for the detailed yet comprehensive and unique perspective, especially with the opening remarks you had vis-a-vis the family as an institution itself, and ending the discussion from your side with regard to the modernization of the family law, whether national or international. Thank you so much. And ladies and gentlemen, let me remind you, we are here on behalf of the Bar Council of Punjab and Haryana through Vidi Talks, which is an initiative taken up by the Bar Council of Punjab Haryana for the legal discussions, book launches, webinars, and legal ceremonies. So let us move on to our next stalwart. We have a senior advocate. Yes, sir.
Ram Gupta has joined. Can you please introduce him?
Yes. So we have, ladies and gentlemen, Dr. Balram Gupta with us. He's a emeritus professor as well and a designated senior advocate, the only one with both the recognitions, ladies and gentlemen. His journey has spread over 55 years. We give you a warm welcome, sir. All right, ladies and gentlemen, let's move on to the next part. And we have senior advocate, Mr. R.S. Cheema, who's a noted Indian lawyer who practices primarily in the Honorable Supreme Court of India and Punjab and Haryana High Court at Chandigarh, and has appeared in all the courts nationwide from the time to time. He began his career in 1977 and too soon rose to a position of prominence. He was designated as a senior advocate by the Punjab and Haryana High Court in 1991. From 2005 to 2007, he served as the worthy Advocate General of State of Punjab. In his inviolable career, he has had the opportunity to be associated with various cases involving important legal issues and national importance. He has been appointed as a special public prosecutor by the Honorable Delhi High Court in the 1984 anti-Sikh riots case. He was appointed as a special public prosecutor by the Honorable Supreme Court of India in the coal scam trials. And he has been appointed as a special counsel for the state of Punjab and UT Chandigarh in major cases under the Prevention of Corruption Act. Also, amicus curiae across widely important legal issues across various high courts across the country, including his parent high court, Honorable Punjab Haryana High Court at Chandigarh, in number of matters, including highlighted cases of alleged rapes of intellectually challenged victim, a full bench matter dealing with compromise quashing in non-compoundable cases, and the very known 2G trial. And he has represented a number of political leaders of national importance across all over India, ladies and gentlemen. So we will give you a warm welcome, sir, and we would like to have your take on the subject, please.
Honorable Justice Sikri and distinguished panelists and distinguished audience, I'll start with the amazement which I went through when I read this amazing book. Mr. Anil Malhotra has been at the screen for 40 years, and I'm his senior by about 10 years. When he chose this field, I'll tell you a minute later, I was worried. I thought the man is investing himself with his talents in a field where the scope is not much. But I also found that there is not much for a lawyer to do, which I'll justify a minute later. But the man had a different vision. The man had a tenacity and a single-mindedness with which he invested himself into a subject where he became a game changer. Family law today would not be what it is minus his contribution of his co-author and brother Ranjit, and the present book. The various dimensions of family law, the deficiencies of our court law, the failure of the law to keep pace with life, the contradictions between the past and the present, the religion and the secular, the diversities in the country, all these things he studied. He combines himself, the persona of a lawyer, a research scholar, an author, an intellectual, and today we are proud to have him here. And the three Malhotra Musketeers have, I have no hesitation to say, played a kind of role in building the blocks for shaping family law, which will be remembered for a long time to come. The present book is, as I said, a monumental work. It is many works viewed from different points of view. It's a handbook. If you want to turn to the Goan law, you will look at it. You want to look at the Muslim law, you look at it. If you want to see something about the surrogacy, you will look at its chapter. But it's a reference book, and I would call it a book of encyclopedic dimensions. It's a book of the future. The contribution of this book is that when the parliamentarians sit, when the judges sit, when the academics sit, when there is a discussion in the international fora for how to change things, how to make laws on the family issues more acceptable, more just, how to build a consensus around, this book and other books by Malhotra's will provide us a very, very basic capital. And therefore, I believe we should all welcome this great book as a contribution which is going to last for a long time and which will lay the foundation of all future work within our generation and the generations ahead of us. I don't think there can be a greater contribution to a subject than coming with one book which touches all the aspects, transcends the various conflicts coming into, goes across borders, goes across centuries, deals with the archaic and the modern laws, and then thinks of a way forward. Now coming to something which surprised me, Mr. Malhotra has been very kind to me. He's presented me all his books. But when he wanted me to be a part of this, I was very hesitant. I have a confession. Where Mr. Malhotra succeeded as a family lawyer, I failed miserably. I started my practice in 1977-78. The 1976 vastly amended Hindu Marriage Act had come. You know, the date is 1955. So I studied it very deeply and I chose it as one of the main fields of my practice. And what I found is worth sharing. The law was totally at variance what the societal instincts, intuitions, and beliefs were. The marriage was still, in the eyes of the Mufassal judge, a sacrament. The divorce was something not to be granted. And the clients I got is interesting. I was in district headquarters at Karnal. This is necessary for us to understand, to see how much we have moved and how much we will need to move further. In Karnal and Kurukshetra, almost 4 out of 5 petitions for divorce were by males, the husbands. The woman would not seek divorce. The reasons were they were vulnerable, disadvantaged. The only cases of females which came to me were of a kind where the man was either suffering from a very serious mental problem or it had an issue like potency. The other matters were not there, and then the cases were badly drafted. The evidence was all made up. The cruelty case would all every time start with, when my friends came or when my uncle came, my wife would not serve them tea. Every petition would have that. The evidence would be of that kind. The cases would fail. So therefore, it was a situation where you would not get divorce, even in the most appropriate cases, partly because of the contribution or lack of it by the council, partly because of the mindset which treated marriage as sacrament and divorce as something to be extraordinary. Now, under 1976 law, one of the grounds which was introduced was 2 years desertion was one of the grounds. Cruelty was another of the grounds. Then the grounds were also like adultery. The grounds also were change of religion. But the standard grounds were cruelty, desertion. But all the cases would fail because the oral evidence in this country has never been acceptable. The theme of all this I'm saying is Malhotras have discovered in their entire work that the laws fall far behind life, that there is a deconstruct between the laws as we operate and the way the life moves on. And the gap has been actually filled by the judiciary sometimes by things done which are not necessarily legal. Now I'll share with you in a lighter vein one of these stories. In the High Court, one of the most big efforts I made in a divorce petition was an appeal on grounds of mental disorder. It was a case of schizophrenia. I was before Honorable Justice S.S. Sandhawalia, the bench I could wish for, and Justice Khan. And at that stage, I got a hearing for 3-4 days. The presiding judge went into the English law, the change, the amendment, everything. The judgment was reserved. It looked like I've made a big breakthrough, but the judgment eventually came on a point which will shock you also. The judgment said, petition dismissed for delay because you came here after 4 years. So all that I want to share with you is that a man before you is a failure on that law. And years later, Justice Khan was presiding over criminal DBs and I was appearing before him every day. So he remembered this case. One day he asked me in the court, well, Mr. Chima, are you still knowing matrimonial cases? I said, no, my lord. It's easier to get a husband acquitted in a murder case than to get him a divorce. So this is the point from which we start. And we haven't changed much. You look into the High Court annals, no case is decided within the period prescribed in the statute in the lower court. No appeal is decided in the High Court. When the appeals come in the High Court, those were the last appeals I handled some 25 years back. The court says, what do you want? How much? How much do you want to pay? Eventually, the cases are not decided on law. Your statute remains unread, and then the parties come to a conclusion. Then there is another breakthrough which I want to share with you. The game changer, the woman strengthened and empowered. In 1983, we had 498A. Now 498A gave a lot of material to the lawyers also. On the slightest thing, cases would be filed, the whole family would be made accused, and the woman was weaponized. But out of 500 cases, which I almost statistically counted, in 499, the marriage broke. The 498 cases, if 10 was registered, not even one would go to a trial. The matter, the threat of that case would only be used to hike the permanent alimony. And the game was, if everybody gets bail, the bargain would be for less. So that is from where we have started. And where have we reached now is interesting. We have changed, but not changed much. We now again in a situation where you all know, and this book deals with it in depth, the power under Article 142 being exercised by the Apex Court. The legislature, for the first time in 13(2)(b), recognized a very important principle. The principle was marriages can be limping. Marriages may be irreparably lost and dumped. A bad marriage has to be given a closure, but this was never made a ground for divorce. 13(2)(b) for the first time introduced a breakdown marriage as a ground if the parties agree to a divorce. And then the Honorable Supreme Court in various cases, taking cases one by one, said, well, breakdown is a ground, we can do this. And we were waiting what the High Courts could do. Interestingly, the High Courts also started building on that. Again, we were bypassing law to do justice. I'm using the phrase, bypassing law to do justice. Now, High Court say, I read two judgments, I would not name the judges. One judgment says, look, They've been separate for 10 years. And now we have asked the spouses. One spouse is very adamant. She is not agreeing for a divorce. This amounts to a cruelty. So you also fill that block, bake it. And another judgment, a very recent one, that without the power under Article 142, the breakdown has been brought in. Therefore, I believe the book which we are dealing with deals with basic questions. The book does not spare anyone. The book notes in the Indian context that while JJA, the Justice for Juvenile Justice Act, has one set of standards for adoption, our other laws are not keeping pace with it. While for Adoption and Minorities and Guardianship Act, we have an act of 1956. For going to a court, we have an act of 1890. We go to that act. Then when we go to a question of guardianship, we say mother is a natural guardian. We are not looking at the welfare of the child. And where this book is making a breakthrough, one of the points on which I believe we have to go ahead and look into this book very deeply is the very concept of a one-parent guardianship we have accepted as the final word is shaken here. And look at now the whole thing from the point of view of the child. How for years we have allowed this one-parent guardianship to be the norm, because we all know that when the visiting rights are given to the other parent, the situation is so hot at the ground that it is never permitted. But we have not paid attention to the fact how psychologically the kids who are entrusted to the custody of one parent and who are denied a complete parenthood and a shared parenthood suffer in the long run. So this book touches this aspect. This book touches the aspect of surrogacy and says why surrogacy is not available to a single parent, why it's not available to unmarried couples, why it is not available to same-sex couples. This book raises basic questions on that. Furthermore, I think on maintenance, the book is the authors are coming now with ideas, borrowing from various jurisdictions and looking into what would be the best in the interest of justice, in the interest of all parties concerned. I have no hesitation to say this is a book which I like to read and reread again. And this is a book on which we need serious debates to take things forward. For instance, we'll have to deal with our laws, look at their contradictions, look at their being redundant in many ways, and then see how the things are to be put together. So my salute to the two Malhotras and also to Ranjit Malhotra, and my salute to three Malhotra Musketeers for giving us such a great. But I want to, in the end, say a word to the Bar Council also. It's a good initiative by the Bar Council. But in my personal library, there are two books which I like to mention. One is a book by the Bombay and Goa Bar Council, published in 1993, on cruelty against women, suicides and dowry deaths. I expect our Bar Council to be coming up with a work like that. The second is even more important. In Bombay, there was a very well-known lawyer by the name of Vacha, V-A-C-H-H-A. He was a renowned lawyer and an author. In 1961, Bombay was having its centenary celebrations. He was approached by the Chief Justice to write a book on the history of Bombay High Court. The book is famous. It's a seminal work. It says famous judges and lawyers of Bombay. He said, only on one condition, that I will not sacrifice my independence as a writer and historian. It was agreed to. The Sanitary Celebration Committee read the book. It was a wonderful book, but they said, well, these are the problems. He agreed to them. They said you will also issue a disclaimer that the views are his. He agreed. One difference persisted. The difference was Lokmanya Tilakji was tried in the central court there. And in his second trial, again, he was convicted for, as you know, sedition. When the country gained independence, a marble plaque was placed there where his words were brought to undo the. Vacha in his book had in manuscript had said, this ought not to have been done. Look at the man's credentials and credit. He said, no, I'm not going to compromise. But look further at the Bombay bar, then led by great Sirvai. They said, we will publish the book, withdraw it from the Sanitary Committee, and the book was published by Tripathi for a small price of 12.5 rupees. And the book is again now available in Universal. So my last word is to our bar councils, please ask these authors to write for you smaller books, more useful books, and see that these books are read. This book is a great contribution to law, evolution of law, and my very heartfelt salute and compliment to the authors and to the youngest of them most of all. Thank you very much.
Thank you so much, sir. That was a very interesting perspective, and especially with regard to the suggestions. Ladies and gentlemen, dear viewers, dear panelists, the Bar Council of Punjab and Haryana has come up with a with a quarterly issue also called as the Council, in which all the legal luminaries can express their views along with the publication of the articles. And I will, sir, certainly convey these remarks and suggestions to the Bar Council members for the adequate implementation as well. Thank you so much, sir. And now, ladies and gentlemen, let's move on to Emeritus Professor and Senior Advocate, Dr. Balram K. Gupta, who is the only one with both the recognitions, and his journey is spread across 55 years in the legal side, from legal education to legal profession to judicial education across and beyond the country. He is the former director of the National Judicial Academy, India, director academics of the Chandigarh Judicial Academy, dean faculty of law at the Guru Nanak Dev University, Amritsar, professor and chairman, Department of Laws, Punjab University, Chandigarh, and parliamentary fellow, Institute of Constitutional and Parliamentary Studies, New Delhi. His autobiography, My Journey with Law and Justice, was released by the Honorable former Chief Justice of India, Dr. D.Y. Chandrachud, on 29th of January 2022. Shaping the Judges, Essays in honor of Dr. Balram K. Gupta, editor Dr. Shruti Bedi, 2025, has also recognized his works and spoke on highest regards. Dr. Gupta is a columnist for publications and Indian Express and Lawyers Update. And interestingly, the Capital Foundation honored him with the prestigious Justice M.C. Chagla National Award for outstanding and distinctive contributions in shaping and mentoring judges in India and abroad in the year 2025, ladies and gentlemen. And the Pioneer in the Legal Arena Award in 2024 for incomparable contributions in the domain of public law by Maharaja Agrasen University, Himachal Pradesh. Distinguished Achievers Award by the Punjab University in 2019. Punjab State Award of Nyaya Ratan in 2006. And you will also be pleased to know he's a social worker and a kind-hearted soul who is also a chartered member of the Rotary Club of Chandigarh Midtown since 1976. So we wish you a warm welcome, sir. And over to you, sir, with your kind inputs on the subject matter, please.
Thank you so much for your such good, generous introduction. Honorable Mr. Justice A.K. Sikri, the distinguished panelists, I feel so good this evening that this particular book has been brought by the Malhotras, earlier the Malhotra brothers, and now the latest, Ankit, Anil's son. I have been associated with Malhotra brothers, Anil and Ranjit, for a long time. I've nurtured them as students of law and also cultivated them thereafter. Anil, in particular, had been coming to the National Judicial Academy in the programs, particularly in the domain of family law. And in that particular context, his contribution to the family law in the National Judicial Academy and later with the Chandigarh Judicial Academy has been tremendous. This is not the first book. This is probably the 10th book which has been brought out. This speaks for the fact that they are professionals, and the book is based not only on the academic studies, what they practice, what they have contributed to the profession. They come out with a book periodically. And the beauty of the book is this is based upon the revolving law in the field of family law over the decades, for that matter. I remember that Ankit used to come with Anil to the National Judicial Academy as a young student at that particular point of time. I feel so good today that Ankit has come out so well and has started contributing. My best wishes to him as the future author, professional, and we look forward to his rich contributions in the different domains of law, and in particular, the family law. I had contributed preface to the earlier book of Malhotra brothers of the year 2013. And in that particular book, I had focused on that this particular book brings out the mixing of the constitutional law with the family law. Family law is a private law. Public law, it is not the domain of the family law. And therefore, this particular aspect, I wish this evening to focus particularly as such. In the year 2013, the book has referred to this particular aspect which I had brought out. But the present book deals with so many aspects of family law, which hinge upon and really are being nurtured now on the foundation of constitutional law. That's the beauty of this particular book. It has been brought out very well. I, as a student of law in the early 1960s, was knowing customary Hindu law, family law, and gradually the statutory family law. But the exposure of the family law to constitutional law or public law is a later development. And this particular focus is equally important and significant when I touch upon certain aspects in this particular context. Take, for instance, Article 21 guarantees the right to life and personal liberty, to choose a life partner, Can there be any restrictions, even of reasonable nature for that matter? Can we really circumscribe the personal liberty of an individual to choose a life partner? What others have to do with that? It's my right. I have to choose my own life partner. I remember as a young teacher, the students had gone to the head of the department, Dr. Shiv Dayal, saying, we want Balram Gupta for this particular subject to be taught to us. Dr. Dayal told them, go to the class. I would come and address you. And he started by saying, you can choose your wife, you can choose your husband, but you can't choose your teacher. That's the kind of a situation that you have absolute personal liberty, freedom to choose a partner. And that is exactly what the Article 21 and the Supreme Court has held in this particular context. In Shaffin's case, in the year 2018, this aspect has been brought out so beautifully. And therefore, the kind of restrictions the family, the society, and others impose in choosing a life partner becomes a lifelong problem for that matter. Consequently, in this particular context, this right has been recognized as a part of right to life and personal liberty, which brings in the family law and the public law, the constitutional law. Come to the aspect of marriage. Divorce is another aspect of it. In the context of the union of marriage, many issues, many problems, many discords come up. Now, therefore, divorce is an integral aspect of the institution of marriage. The parties can't live together, and therefore they wish to separate. The easiest way is mutual consent divorce. If the parties can mutually agree, the whole issue can be resolved easily, comfortably for that matter. Now, under Section 13B, there is a period stipulated of 6 months, the cooling period after having put in the petition for a mutual divorce. In this particular context, the Supreme Court has invoked Article 142 and has come out with this, that even this period of 6 months may not be carried out. And the parties mutually, if they agree, can divorce, and a decree of divorce can be passed in order to do complete justice in consonance with Article 142 of the Constitution. Now, see, this is a situation where a statutory provision is there and where the court is satisfied. It's not that in every situation that they would do this. The book brings out so beautifully this aspect also. But in exceptional situations where the court is satisfied and convinced of the fact that it is necessary not to have this period of 6 months, and a divorce decree is granted for that matter. Similarly, in this particular context, further, when we talk about divorce on different grounds, statutory grounds are stipulated in Section 13, and a situation often has risen where the ground is not stipulated and there is an irretrievable breakdown of the family. This aspect has also been dealt with in the book so very well. What I'm focusing is the silence of the legislature, of the legislation as such, where there is a complete breakdown. The repair of the marriage is not possible. It's irreparable for that matter. Once again, Article 142 is invoked in that particular context. And in that particular background, invoking Article 142, bringing in the irretrievable breakdown of the marriage for that matter, the decree of divorce is granted. The practicability is a public cause. Parties suffering, they cannot live together. Why should there not be such a thing that in order to do complete justice to the parties, this is carried out? There is a criticism in regard to this, that this means that you can go beyond the written word of law, the statute, beyond the rule of law for that matter. Answer is, everything cannot be capitulated, included in the law for that matter. And therefore, in that particular background, if the court is satisfied, it would exercise this jurisdiction of Article 142 for that matter. You know, the Law Commission of India, in the year 1978, which has been brought out in this book, has dealt with this issue so very well. If the Parliament has failed to bring in a law in this context, the gap has to be filled up in order to do complete justice through the medium of Article 142, which is the foundation of this particular book in this particular context. Furthermore, you know, for instance, the custody of children. A child is removed from one jurisdiction in spite of the court order to another jurisdiction, to another country. Can we invoke the prerogative writ of habeas corpus? This aspect also has been covered so very well. See, it's a public law remedy, not to test the legality of the removal for that matter, but to go to the depth of what is in the best interest of the child, that the writ of habeas corpus is invoked. That is how the public law is penetrating into the family law, which is the focus of this particular book, and I'm focusing only on that particular aspect. There are many, many other aspects, but this aspect has been dealt at length, in detail. Otherwise, one could say, well, that's not a matter of private law or family law. Why go into that domain? You know, this blending and mixing of the two has become inevitable. And therefore, that is being carried out effectively in that context. Now, take, for instance, Justice K.S. Puttaswamy's case, again of the year 2018, it has recognized right to privacy as a fundamental right to be read in Article 21 of the Constitution. And the right to privacy further includes the right to reproductive autonomy, for that matter. The two are interconnected. It's integral to the ambit and scope of Article 21, which has been dealt again in this particular book, for that matter. Now, that brings us to the issue of surrogacy. You know, the foreigners can come to India and adopt Indian children, for that matter. This is permissible, and there is no embargo on that aspect, for that matter. Of course, certain conditions are stipulated under the CARA rules, and therefore they have to be carried out accordingly. In the matter of surrogacy, there is a very, very serious attempt not to permit it as ought to be permitted, for that matter. The whole aspect as to why the government has a conservative view about surrogacy, I can understand certain issues relating to the exploitation of the surrogate mothers. And sometimes the issue can also be of the child or the children, surrogate children for that matter. If the parent refuses to have the child, what consequences would follow? The child human rights are to be kept in mind, for that matter. That again is the purview of Article 21 of the Constitution, and in that context, this aspect has to be taken care of. You know, a detailed study has been done in this particular book. Various aspects have been covered comprehensively, in detail, in depth, for that matter. But then what happens is, what the suggestion of the Malhotras is that let there be restrictions to regulate surrogacy and not to jeopardize, completely prohibit, stop, for that matter. I can understand commercial surrogacy is not to be allowed. Though, of course, Malhotra brothers and Ankit also take the view it involves the right to livelihood. Yes, it does. But then commercial surrogacy has its own side effects. For instance, organ donations. They also formulate part of the entire aspect in this context. And therefore, what is to be seen is that this aspect needs to be looked into more deeply, practically oriented in that context. In short, my focus being that how the family law has been penetrated with the reasonableness, the public policy, the public concept, public interest, and focusing on this aspect, mixing the two, is a good blend, which is a rich contribution of this book. I'm not undermining the other aspects, but I wanted to limit myself to this element of bringing in the public element into private law, which has been beautifully done in this book. I highly commend this book, and I'm sure this book would be for the future in the context of the Constitution also. It would bring in a revolution when it brings in the public law, the Constitution. Constitution is the mother of all laws, and therefore it is not the legitimacy alone, constitutional aspect, constitutional morality into the family law also has to penetrate for that matter, which is an aspect for the future for this particular, in this particular context, which needs to be carried out. I highly commend the Malhotras for bringing out this monumental work and focusing on this aspect. One more aspect for the Bar Council. I'm so very happy that quarterly council which is being brought out. It is a beautiful effort. I commend it, and I wish that it should be continued with full vigor, which is a platform for the lawyers, for the judges to contribute immensely in this particular context. I wish Anil, Ranjit, Ankit the very best and look forward to his future contributions. My blessings to the Malhotra companionship for that matter. Thank you so much.
Well, thank you so much, sir, for such a detailed examination, not only on the book, but the intricate topics related to the book, especially your personally favorite pick topics. Thank you so much. And ladies and gentlemen, let's move on to the next esteemed expert we have. Well, all the panelists here will refuse themselves to be called as an expert because, as Sachin Tendulkar was quoted by Mr. Harsha Bhogle, once he said, Sachin is the master of the game, but always gave servitude to the profession like a servant. That is what I would like to say about all the panelists here today. And our next panelist is a renowned lawyer, Advocate Mrinalini Deshmukh, who's a renowned lawyer with vast professional experience in family law. She is an alumni of St. Xavier's College, Mumbai, and holds an LLM from the University of Mumbai on the commercial law and matrimonial law. She has been a professor of the constitutional law as well. And ladies and gentlemen, she is a visiting faculty at the Mumbai University. She has been at the TED Talk speaker on and addressed various issues of sexual harassment at workplaces and safety of women and children. She participates in domestic and international conferences on the issues related to family law, structuring of the wealth and alimony issues. Also, she has strongly believed and always believes in the gender justice and is extremely sensitive about injustice and the malpractices propagating gender inequality, and she propagates the gender equality. She has authored a very wonderful book on the topic, Divorce, Breaking Up Your Step-by-Step Guide in Getting Divorced, published by Penguin. And she has dealt with cross-border legal cases relating to marriage, divorce, validity of foreign court orders, applicability of Indian laws of marriage, child custody cases, effect and enforcement of foreign court orders, validity and enforcement of Indian laws on child custody, with specific reference to the foreign jurisdictions, foreign court orders, and such other related subject matters. She's an arguing counsel and attorney appearing all over the country. She presently is welcoming us while sitting in Germany, ladies and gentlemen. She has been invited to give legal opinion in foreign courts also, and has been also been examined as an expert witness and given various multiple opinions on the applicability of the Indian family law legislations. We wish you a warm welcome, sir, ma'am, and we would like to have your wonderful inputs on the subject matter, please.
Ma'am, you have to unmute yourself.
Good afternoon. It's indeed a great pleasure and honor to be a part of this esteemed panel. And I'm personally and professionally grateful to Mr. Anil Malhotra and to, of course, Mr. Ranjit Malhotra and Ankit, that little boy whom I saw as a student who had come to me. Oh my God, he has blossomed and flowered like a wonderful, not only a professional, but the hidden talent that he had, which is all over in the book that has been there. Can I confess, Ankit, I have learned from you. You had come to seek my opinion, but your book has been an absolute, of course, it's been your father's guidance, who's been the guiding star. But it's really absolutely, and this is an honest confession before this panel, that after I read this book, I have learned a lot of things which I personally never knew or professionally never knew. And this has been a great eye opener and insight for me. So I'm truly grateful to both Mr. Anil Malhotra, Mr. Ankit Malhotra for the book, and of course, Mr. Ranjit Malhotra, who is the spine and who is the wind behind the wings of Ankit and Anil ji also. I must also thank the Vidhi Law and the wonderful work that the Punjab and Haryana the High Court is doing in having these kind of sort of sessions, which not only empowers and sort of emboldens the legal structure which is there, but also throws a light on the ever evolving and the ever changing issues that we as students of law, we as practitioners, we as teachers, and we as, and some of us who are here as, who's been in the judiciary. I'm so grateful to them. Justice Sikri, I mean, I have appeared before you, and I can only say I'm truly honored to be on the same panel as you and learned so much during the course of the arguments in the Supreme Court. Of course, they were issues related to family law. My scope is very limited, and I'm ever so grateful. Mr. Balram Gupta, what do I say? It was the most sagacious words of wisdom, of experience, and of somebody who has literally churned the law and who has explained. I have also been able to absorb a lot of things from your discourse this afternoon. And I think I'm feeling much more enriched, Mr. Anil Malhotra, than what I was at the beginning of this conference. After having heard all these stalwarts and in every sense of the word, and given their views not only on the book, the contents of the book, the amount of effort that has gone in behind the book, because to collate so many things and which are of so much relevance and so important in today's times, as practitioner I can say, is an enormous job that has been done. But what I truly like about this book is, and I would like to say is, it is a complete treatise for law practitioners, for law students who want to know about basically cross border issues, who want to know basically about international law, who want to know a lot about how it's happening. Because today the world is getting smaller, we're becoming one. Globalization is the rule of the is the rule of the day. And under such circumstances, even the concept of family law and the concept of cross border issues owes a lot of relevance. As all the esteemed speakers have said before me, it's very important that do we find this in any of the statutes? The concept of NRI marriages, the concept of cross border issues of custody, of the cross border issues. I'm talking about the family law, cross border issues about the marriage, the divorce decrees passed, the orders passed, the execution passed. This is all a part of the evolution of law, which has happened post the statute. Because in 1955, the Hindu Marriage Act was there. The Hindu Marriage Act did not have this concept of a non-resident Indian, did not have a concept of what happens to cross-border issues, did not have the concept of what is included to be considered as far as the parental alienation is there. It does not include issues like what happens if a child is uprooted from one country to the other country because one parent wants it so. What are the rights of the child? All these things are not found in the statute. And in my understanding as a student of law, I have learned that this has grown, this has become a part of our legal system, thanks to the various judgments which are there. All of us know that the landmark cases like Satya versus Teja of 1975 Supreme Court or 1991 of Narasimha versus Venkatal Lakshmi, and subsequently some of the high courts also, which have given or Gopal Sandur versus. So all these cases have evolved the law, and these laws have now become a part and parcel of our legal system. What I find very, and I won't take much of your time because a lot has been said, and we all need to absorb what the earlier panelists have said with so much of their experience and expertise. What I have realized in my case is that every time a new case comes up, I find, and this is my observation, may not be true for all, that the approach of the courts at times changes. So I be able to say, if somebody asks me, what is the rule or the law as far as Supreme Court of India is concerned if a child is abducted from his usual place of residence? What is his usual place of residence, his or hers usual place of residence? How do we decide whether the usual place of residence is the welfare of the child, or whether being with a particular parent is the welfare of the child? And what is the welfare of the child? Because these concepts are not defined. The concept of the welfare of the child is a very, very fluid and a very, how do I say, things which have to be adopted and adapted as per the facts of the case. So that is leaving a lot of us, and this is what I experience, a lot of us with a lot of uncertainty. I would not say little bit, but a lot of uncertainty about what would be the court's view in a particular case. Because if we go through all the various case laws, and I'm just, if I limit myself to the child custody cases, or where the children are abducted because of parental abduction, and what are the concepts of parental alienation? Why is it that the child should be given to a parent? And I'm not mentioning the gender of the parent because I don't want to make it anything controversial. Why should the why should that parent be given a preference who may have committed parental abduction for his or her own good and not for that of the child? And how is the court is going to determine these factors in the given set of circumstances? I do understand these are all to be applied as per the facts and circumstances of the case. There cannot be a straitjacket in law which is there, which will enable the courts to frame guidelines or to give some kind of indication that this is what the views of the court are, or this is what the court believes is going to be there. Today, in my opinion, it is still a lot of gray area that is there in cases of there. Mr. Malhotra has been able to deal with a variety of these cases, and this is why I call it a treatise, and has given us different nuances, as also different aspects of what the situation could be, what could be the law, or what has been the law, and what has been the finding of the court. What I'm looking at is, and I think I'm using this forum to put forward, can we not have some kind of guidelines issued by the courts? Or some kind of, I mean, I don't know what are the other words that I can use to be able to have for, because if a young lawyer comes to me and asks me that, ma'am, you've dealt with a lot of these cases, what do you think would be what could be the stand of the court? What is the law and how does it? I will have to say that yes, the courts are going to look at the welfare of the child. The courts are going to, at times, if the child is of an intelligible age, try and gather from him or her the preference. So these are the normal parameters which are there. But I feel that some kind of guidelines are absolutely necessary coming from the highest court. And I do not know whether we need to have an amendment to the statute, or whether we need to have any kind of extra rules which are to be added to these kind of issues that come up. because unless that is there, there could be a lot of uncertainty, and that could lead to a lot of, gray areas in the evolution of law. Justice Sikri has absolutely absolutely stated that there is Section 13, which is of the Hindu marriage, sorry, of the Civil Procedure Code, which lays down what is the order for all foreign decrees are to be executed. Exceptions are A to F in Section 13 and Section 14, which is talks about it. Mr. Balram also said that there could be a case where there is a law which an order which has been passed by in favor of the husband, and that could be an ex parte order by a foreign court. And could that an ex parte order be executed over here? So we have Narasimha Rao's judgment, and we have Sonur Gopal's judgment, and we have Satya versus Teja's judgment, which gives us that what could be the law. What happens when today, and I see this increasingly in my cases, what happens today is quite a few women, and I'm sure they do it for their betterment, despite knowing what the law is, despite not having a domicile of the country which they are residing, despite having the knowledge about it, that okay, it's 6 months of residency or 3 years of residency, whatever the case may be, gives the court that jurisdiction, is invoking that jurisdiction more to get better rights in the assets and the properties of the husband. They feel that the Indian laws are not so sort of attuned to understand what the marital assets are. As we speak, and I'm absolutely subject to correction, and I mean to get learned from all of us here, that as we speak today, we do not have the concept of equitable and proportionate distribution of the marital assets. We have Section 27 in the Hindu Marriage Act, which talks about the properties of the parties. But it just talks about the property, it does not talk about the division. Section 27 of the Hindu Marriage Act is on most occasions applied in case of women for their stridhan or for their jewelry or things which are there. But today we do not have this concept of an equitable and proportionate distribution of the marital assets. What are the rights of a wife who has invested, say, 20 years of her life in a marriage or 25 years of her life in a marriage, given birth to children, raised them, done everything what she felt was well within her powers to raise the family. And tomorrow at the end of the day, for whatever reasons the marriage goes sour, what are her rights and what does she get here? Is it why she's tempted to go and invoke foreign jurisdiction and try and get some orders which are favorable? But then the problem arises, and I'm talking about this because I'm currently doing a case. And then the question arises that it becomes difficult to execute a decree of a foreign court, especially when it comes to the financial agreement, financial aspects which has been declared by the courts. Thirdly, and more importantly, how is it defined, as Mr. Balram Gupta said, or also as Justice Sikri said and Mr. Chima said, that at all points, what we are going to see is the welfare of the child. Who is deciding welfare? How can we define it in a better manner for the courts to have a consistent stand on it? And that is what I would like to say. Because I, in my limited years of practice and my exposure to this, have noticed that there have been various judgments which have been, to some extent, not in consonance, if not exactly contradictory to each other. That leaves, all of us in a state of maze, not knowing what the law is. That is why I started by saying that though it is not there in the statute, and it is something which has evolved by judicial activism, and as globalization happened and as families started residing elsewhere. In fact, this afternoon only, I was asked at one of these forums about what is it that will ensure that whether a registration of a marriage, even performed on a foreign soil, will it ensure that the wife gets her assets in India from the husband? Now, these are very, I mean, just an example I'm giving you. These are kind of questions that come up, and these are the kind of things that come up, which honestly, I don't have answers to all of them because I can't really pinpoint and say, okay, this is what the court says. This is what I can say the court has held this in A and B, and the court has held B in this. They'll say, we understand A and B, but what is the law? And then it becomes difficult to explain to them. And that is why I feel, with all these experts on this panel and and Mr. Malhotra, where you've taken so much of an effort with Ankit, whether we could make a representation of this to to the Union Law Ministry or to the concerned people to debate, to deliberate, to have some law and to do, because ultimately you and I can only talk as lawyers, but ultimately the law, if it has to be made, guidelines have to be done. It has to be done by the legislature. We know the separation of powers. So how is it that we can do is also something I think we need to think about it, and we need to sort of put it in a manner and make this webinar, Mr. Malhotra and Ankit, a little more than just intellectual discussions, or at least from the way I've absorbed everything, to be put it and translated into action. And I think they have a lot of ready-made stuff that you have given. And when I use the word ready-made, is they don't have to sit and apply their mind and deliberate about it, because you have given them a lot of things for them to do so. So my only suggestion, and also to the Vidhi Law and Justice Sikri, if I may even address you on this point, being the ex-Supreme Court judge, whether Justice there could be some way we could reach this to the lawmakers to make them, I mean, deliberate over it. We can't tell them what is the law. They are the majority. But if we can do that, it will really be very, very useful. And I think it would be very meaningful for everybody as practitioners, as people who are in it, and we can deal with a lot of these issues. I think that's all that I really need to say. And I thank Mr. Malhotra for giving me this wonderful opportunity to really, really brainstorm with such profound legal minds as we have on this panel. I really go back very enriched learning from all of you. Thank you so much. Thank you very much.
Thank you so much, ma'am, for those unique perspectives and analysis on the subject matter of the family law, and especially the issues of the national importance, which may be brought out through legal luminaries like your good self. And with the permission of all, let me move on to the next speaker. We have a very eminent personality here with us. Padma Shri and former IAS officer, Mr. R.I. Singh is here. Mr. Rameshinder Singh is a distinguished civil servant of the Punjab cadre who was conferred with the third highest national honor of Padma Shri in 1986 at a young age of 36 years. During his long career of 40 years in the public life, he has served in the state of West Bengal, the state of Punjab, and Delhi in government of India. He held many crucial appointments, including as a district magistrate Amritsar during the 1984 to 87, and as principal secretary to the Chief Minister Punjab for 5 years, Chief Secretary Punjab for over 2 years, and from that position, he took premature retirement from IAS in the year 2008 to serve for 5 years as the Chief Information Commissioner, Transparency Watchdog under the Right to Information Act. Before joining IAS, he taught political science in New Delhi. He is MA in political science, having taught Punjab University, and we are proud to say he is from the soil of Punjab and is a law graduate LLB from Delhi University as well. He has also worked as a consultant with the World Bank. Ladies and gentlemen, he has authored a book in English, Turmoil in Punjab, Before and After Blue Star, and in Punjabi, Dukhant Punjab Da. Currently, he is the director on board of Institute of Development and Communication, IDC Chandigarh, an autonomous research, training and evaluation organization working in areas such as peace and conflict resolution, public affairs, and economic policy. He also is the advisor. He is also on the advisory board of India Strategic, a monthly journal on defense, homeland security, and strategic affairs. We would like to know your perspective on the book, sir. Please.
Thank you very much. Honorable Justice Sikri, distinguished panelists, and Malhotra family. I am privileged to be part of this dialogue, discussion, because I have learned a lot from all the panelists and the legal luminaries. I had the opportunity to go through the book Practitioner's Guide to International Family Law, and I compliment Shri Anil Malhotra, Ankit Malhotra for this commendable publication, which is very comprehensive. It deals, as has been brought out by the panelists, with marriage, divorce, alimony, maintenance, child welfare, custody, guardianship, adoption, inter-country adoption, surrogacy, and also to a limited extent issues involving citizenship as it impacts the family life of the people. The book will be of great value not only to the legal practitioners, as the title says, Practitioner's Guide, but also to a large population of non-resident Indians living abroad who will find it extremely useful because the number of NRIs is increasing almost every day, I would say. We have over 34 million non-resident Indians living abroad, about 5 million from Punjab, and their family lives get impacted because they marry here or they have gone from here. So the issues of marriage, divorce, issues of succession, issues of partition of property, all these come up. The world is shrinking into a global village. Both the Malhotras have done great job in bringing out the various aspects and the legal issues involved in this area. Mr. Malhotra and I had the privilege to earlier work together on governance reforms. He made a great contribution to the Governance Reforms Commission by contributing scholarly papers, research articles, and in bringing about some of even the statutory changes. As you know, compulsory registration of marriage in Punjab or bringing about laws pertaining to compulsory registration of the travel agents, these were highly needed areas for reform and legislation. And these were brought by the Punjab state over a period of time. Mr. Malhotra's contribution in drafting and making recommendations in these areas has been of great value. The legal aspects have been covered by the legal luminaries. I would like to touch on briefly, because we have already spent about 2 hours, on the administrative aspect of this, particularly relating to the non-resident Indians, the international aspect of the family law. Punjab government was one of the first to establish a separate department for NRI affairs with a secretary, principal secretary as its head, to see that the interests of NRIs are taken care of. Similarly, we have a NRI police wing in the department of in the Directorate of Police, which is headed by an officer of the rank of IGP or DGP. 15 separate NRI police stations were notified to facilitate easy resolution or investigation of issues, because in marriage disputes, succession dispute, property divisions, child custody, these invariably, though these are areas of family law, spill over into the criminal aspect also. Then fast track courts were established. Special civil courts for NRIs were notified to facilitate, because it is not just the law or the provisions of the statute, it is also facilitation of easy access to those laws and legal institutions, which is imperative for relief to everyone, but more so, I would say, to the non-resident Indians. The state has also established a portal for NRI complaints, And at the district level, there are NRI grievances redressal committees, to address their issues. One aspect illustration I would like to give is, for example, property disputes, particularly of the urban property, the East Punjab Rent Restriction Act. I mean, it was a very difficult proposition for a landlord to get his tenant ejected, even for his personal use. So this law was specially amended to take care of the NRIs who want to take possession of their properties. Of course, now the act has been superseded by a general law which regulates your tenant-landlord relationship through contract and agreement rather than those statutory protections. This makes me make another observation. When we are addressing these small segments like NRIs, let's say, how to protect their rights, how to assure their legal remedies, we create islands of excellence, administrative convenience. But what is often ignored in this kind of a situation is that the entire population needs that excellence, you see. So the focus should not be only just on creating these special statutes or special codes or special privileges for a section of Indians, NRIs and others, but the effort should be to improve the entirety of our system and justice delivery. The little experience I have is that justice, it lingers and lingers and lingers in Indian courts. It goes from one to the higher, to the higher, to the higher, and it takes abnormally long to settle some of these disputes. So we need to address those issues. One area which is not related, of course, to the civil family law, but which is the outcome of NRIs, people migrating abroad. And I see Mr. Chima on my screen, and I would like to specifically address him that there is a material for another book by him on this issue. Today, NRIs abroad are indulging in illegal money transactions, hawala. They are funding through that money, transfer of weapons to the country. And some of these organized criminals and gangs sitting abroad are, creating havoc in India by targeted killing, by exploitation, extortion, and so on and so forth. So there is this one area which needs to be addressed. I'm extremely grateful to Mr. Malhotra, Anil Malhotra, his brother Ranjit Malhotra, and dear Ankut. They have made a great contribution. I once again congratulate them and also thank the participants, the panelists, because I feel greatly educated by their observations. Thank you very much.
Thank you so much, sir, for bringing on the table those perspectives from your side. And ladies and gentlemen, now is the time when we all can take a screenshot with the book in the hand. I request the panelists to keep the book in the hand. A screenshot can be taken. Thank you. Thank you so much. Thank you so much. And many congratulations to Mr. Anil Malhotra, Mr. Ankit Malhotra, and Mr. Ranjit Malhotra. And we are now open to the floor for the questions. Dear participants, you are requested to send your queries on the Zoom chat, and we will shortlist a few questions and pose them to the authors for their response. Please be concise and ensure that your questions are relevant to the subject of family law or international family law and no other subjects.
Mahir, I would like to make an input here straight away.
Right, sir.
I want to add to what Mr. Chima and Nalini ma'am said. Our laws are outmoded. We are not looking for a change. The vibrant interpretation of the judiciary with judgments like the authored on parallel alienation syndrome by Justice Sikri need immediate resuscitation or revival, the oxygen is the court. And I would like to elaborate a little on what Nalini ma'am said. We need guidelines, we need practice directions under 142. An example of this is straight away Vishakha's case on harassment in sexual harassment in workplaces. A judgment came, and after 15 years, an act came. Law of maintenance is most grey, most unclear, most fluid. Justice Indu Malhotra did an excellent job in Neha versus Rajneesh. And now that has become a following principle, so much so that every divorce petition in every jurisdiction is now required by law made under 142, and if by 141 applicable to courts, that you have a format of maintenance. You can't conceal anything. You have to go on affidavit. What we really need is, we need a similar implant in marriage. We need a similar implant in adoption. We need a similar implant in surrogacy. We need the judiciary to fill in reforms. I had the opportunity to assist Justice Bindal and Dr. Balram Gupta in a 2-year exercise on making a law or suggesting a law on child removal. We drafted a bill. It's gathering dust for 2 years. So what do we need? We need practice directions. We need the gaps to be filled in. We need to catch up. We have so many problems being imported. People think it is easier to get a divorce abroad, but then divorce has to be repeated here. So this distance has to be completed by the judiciary. The gap has to be filled in immediately. We can't keep waiting. And another suggestion I have, we need to develop dedicated family law bars. We need to develop dedicated family law judiciary. We need a dedicated bench like the High Court of London, the family division. So this is something which we need immediately, because the problems are multiplying. And resolution by statute is -0. So
Absolutely, sir. In fact, there are a few questions, sir, that our curious participants are asking, and rather flooding is the wrong word, but beautifully drafted questions. And Mr. Harsh has asked, can you please throw some light on the theory of irretrievable breakdown in the present judicial scenario, especially NRIs, where we see that there are several cases where the wives are being abandoned, especially in the state of Punjab?
I think the terminology of mutual consent needs to be tweaked. As Mr. Chima puts it, you need to add 13B, 1I, 2I, and 3I. And our High Court is already doing it, as in a judgment Mr. Chima pointed out to me. Instead of using the word breakdown, they say the marriage has become unworkable. So instead of the judiciary tweaking the statute, what is required is that irretrievable breakdown of marriage should be added as an extra ground for divorce, with safeguards hedged in, of course. As we discussed, with Mr. Chima, I discussed, we found a judgment where the court is dissolving the marriage as unworkable, but is sending the rest of the affairs back to the family court. So I think 142 is violated, because 142 says do complete justice. So this judgment is doing incomplete justice, not complete justice. So therefore, this waywardness to left and right, rather than burying the hatchet in one go. So when Supreme Court buries the hatchet, Supreme Court is now awarding 10 crores, 20 crores, a custody plan. The best way to do it is, I think, you send the matter to the mediation cell. Supreme Court has a very active cell. You set down the conditions in an MOU, go back to the court and say, this is the settlement, recorded, everything is there, please give us divorce. Instead of irretrievable breakdown, use whatever phraseology, so that the High Court can also use this phraseology. That is the best way to resolve the matter. How long it will take, I don't know. But I think I visualize, as long as I live, by that time, there might be an international family law made by The Hague. There are so many conventions by The Hague. India is a party to the Hague Conference, but India does not actively move in. We need to sign international conventions. We need to become a part of a global family law so that we can reconcile our laws with international laws and provide an easier channel. Why should a Indian person of now this is another issue. If you belong to the Hindu religion, your marriage can only be dissolved by a court of jurisdiction in India. So therefore, why tell an Indian to go to a foreign country to get a divorce? You tell him irretrievable breakdown in India is straight away available. Use it. So
Mr. Anil Malhotra, can I add a footnote?
Yes, sir. Please do, sir.
See, talking about Article 142,
Sir.
you said it's not doing complete justice. It is incomplete justice. Now, take the example of irretrievable breakdown of marriage, where you can't repair the marriage as such. Both the parties are in a difficult situation. And if you let the marriage continue, both parties are suffering. Therefore, if on the ground of irretrievable breakdown of marriage, if the divorce decree is granted, is it not doing complete justice to both the parties? This is my question to Mr. Anil Malhotra.
Sir, my respectful submission is, if you want to do complete justice, you dissolve the marriage, but you settle the ancillary issues also.
Correct.
Why remand the matter back to the family court to settle down alimony, custody, maintenance, child custody? The judge will say, please bring evidence. Then we are back to square one. And sir, my respectful submission, reaching the Supreme Court will take at least 15 to 20 years. You have reached the top and then you're thrown to the bottom. So this partial settlement or adjudication and remanding the matter back is not doing complete justice. It is doing complete injustice. That is my perception. So what do we need? We need a law. We need a statute so that the High Court and the Family Court can adapt to it. Alternative method is let the an appropriate bench in an appropriate given case lay down what 142 does, practice directions or
yes,
or guidelines, which is what happens in England, which happens in India also. Vishakha is a living example, sir. And Justice Indu Malhotra's judgment in Rajneesh versus Neha Kumar on maintenance is another example. So this so to say inside approach of the court lending general guidelines is the need of the hour. Maybe that will become law after 15 years, 20 years.
May I add something here?
Yes,
Mr.
ma'am.
Gupta
Yes,
and
ma'am.
Mr. Yeah, I just wanted to add, speaking on 142, and I'm speaking more from an experience that I've had. We have taken quite a few matters. I'm taken for quite a few matters before the Supreme Court, which have come in transfer petitions or they've come in by way of an SLP, where one of the parties is asking for divorce, the other party is also asking for divorce, or where one party is asking for divorce and the other party is not doing. And we are asking that we need the court to exercise 142 after the constitutional bench judgment. My experience has been, and this is again, I'm limiting myself to my experience, has been that the courts come and tell us, or the courts tell us, have you settled the matter? Have all the consent terms been agreed upon, signed, and things like that? Only then we will dissolve. Now, my understanding, and Mr. Gupta, I think you can also sort of, sort of throw some light on this. If the courts are going to say, if the parties come to an agreement, it's a no-brainer. The courts will grant. I am coming from a different situation where the marriage has broken down. The parties are living separate for 20 years, but one of the party is being very difficult or very adamant that I'm not going to give. Now, should the court exercise 142, the Supreme Court, under such circumstances, even if they have not come to a consensus? Now, my experience is the courts are not willing to do that. There have been a few cases which I'm aware of, but they are something which you can count on your fingers. It is not something that the courts are doing it or as a matter of rule, when they are convinced about the facts that the marriage has broken down beyond repair, it's irretrievably broken down, and parties have left for nearly 2 or 3 decades, they are living separately, or they're not doing anything. So in my understanding, 142 is very conservatively being exercised by the Supreme Court in such cases when the facts are so crystal clear and they are so sort of, I mean, even a blind person could see what the facts are. I really wonder, why is it that the courts are so hesitant about it? Mr.
Let,
Gupta, you have any view on this, sir?
Let me put it this way. See, I appreciate what you are saying, that the Supreme Court is conservative in exercising the jurisdiction under 142. Understandably, it is a provision to be used sparingly. Now, in this situation in which you have pinpointed, I would urge, let the Supreme Court lay down or give the directions that under these circumstances, we have also exercised the jurisdiction under 142, and therefore those directions could penetrate and go over to the lower courts for that matter. And on the basis of that, the entire matter could be. I would totally agree with you that once the parties are living separately, one party is insisting to continue, the other party is not. But there is nothing left of the marriage for that matter in that situation. Now, there's no point in continuing with that. It has to be put to an end. To my mind, that is doing complete justice. But since in some cases the Supreme Court exercises this special jurisdiction, in others it doesn't, something of kind of directions which could lay down a uniformity in situation which lead to irretrievable breakdown of marriage. That's what I would suggest.
Can I for a moment intervene?
Yes,
See,
sir.
142 would always be rare. It will have to be case to case. What Mr. Malhotra has said is the answer. The answer is 142 for a larger question. The question I posed was, kindly look at it. The moment we had 13(2)(b) as a broken down marriage, we had regarded the factum of a broken down marriage, and we had also regarded the legitimacy of a broken down marriage as a step to dissolve it. That is why all that we need is a 13(3). There can be a judicial determination of a broken down marriage. Once that judicial determination is there, the court has to step in. The only thing is the guidelines have to come not in a single case. They have to come as they were in Vishakha's case. I think that is the only answer.
Sir,
And inherent in 13(2)(b) is the recognition of the principle of a marriage breaking down. We say they are not reconcilable. The differences are too big. It cannot be a meaningful marriage. That cannot be something which cannot be judicially determined on the facts of a case.
True.
so I add, Mr. Chima says, we need to add a no-fault divorce ground, like is in UK. Nobody asks any questions. Your marriage is broken down. You get a decree nisi. You settle children, custody, maintenance. You get a decree absolute. Now, this is going to take time because the government will probably take another 15 years to decide all this. Now, what is my experience in child custody cases in which marriage is broken down also, alimony is needed? It's a package. Supreme Court has no time. The benches will spend 5 minutes, 10 minutes. They are overworked. The answer and the resolution I have seen in many child abduction cases is you tell the judge on the first date, my lord, this matter is going to be settled. It is prone to settlement. It is mattered to the Supreme Court Mediation Center. In the Supreme Court Mediation Center, very senior lawyers are handling these matters. At the state level, there is so much family influence on the man or the woman not to agree. But once they come in an independent atmosphere in the Supreme Court, they have already spent 5 to 15 years. The mediators prevail over them to settle on equitable terms. You want 50 lakhs? No, we will give you 30. You want exclusive custody? No, we will give you shared parenting. I have drafted MOUs on children to be allowed to come to India from, let's say, Poland on settlement terms where we keep the passport of the child as long as the father keeps the child in India. And when they go back, we do it. So what is actively needed till the legislature makes the law is more and more involvement of the Supreme Court Mediation Center, or intervention of child psychologists, or intervention of psychiatrists even, or intervention of benches like Lok Adalats, where people can be heard and settlements can be drawn up. This is an ad hoc arrangement. But what we really need is what Mr. Chima says. We need to add 13B to 2I or 3I or another one. That legislative solution is the only answer. There can be no definition of irretrievable breakdown, like there is no definition of cruelty. So therefore, things have to be coined. Yes, Mahir, please.
Yes, sir. Thank you. Thank you, sir, because this is more like a Pandora's box. It is a deep, vast subject in itself. We have time constraints. I would like to have another question to which you can give an answer in within 2 minutes. That is by Mr. Chug. He asks how Guardianship Act can be invoked in cases of NRIs living in different countries, especially in the matter of child abduction. Within 2 minutes, please, sir.
So the very simple answer is, if a child is abducted and brought to India, if the parent of who has removed the child invokes the jurisdiction of the Guardian and Wards Act, a straight application under Order 7 to 11 should be filed that the minor does not ordinarily reside in this jurisdiction. This court has no jurisdiction. Following the judgment of Justice Tirath Singh Thakur in Ruchi Maju's case, the matter can be thrown out and urgency can be expressed in the habeas corpus. And if the judge in parents to pay jurisdiction finds merits, the child can be returned to the foreign jurisdiction. And I think you need a smart lawyer to do all that.
Thank you. So we will confine ourselves to one last question. Mr. Gaurav Chunkar has asked that with the modernization in the family laws, there is a new concept of shared parenthood these days, pre, post, during a conflict also. So would you like to throw some light on it, sir?
See, the problem is that the Guardian and Wards Act of 1890 talks of single custody. The family court judge is bound by statute. It is beyond his mental comprehension to think of shared parenting or joint custody or an arrangement by which this can be done. You must understand that the family court judge is bound by statute. He will not be able to do all this. There are a number of judgments which are cited, and it is the wisdom of the family court to do it as an independent measure. Bombay has been very progressive. They have developed child independent lawyers. They have put up mediation, mandatory consultation, etc. So these are concepts which parties can agree to and then put them up jointly so that a child is best of both worlds. The definition of the best interest of the child in the Juvenile Justice Act in Section 29, incorporating the United Nations Convention on the Rights of the Child, gives a handle. But you need a sharp mind of a judge to actually import these provisions of the best interest of the child in a judgment with an expansive mind. So what do we need? We need more people like Dr. Balram Gupta. We need to activate the judicial academies. We need to train our judges. We need to educate our judges on these concepts so they can incorporate it in the judgments. A smart judge can pick up precedents, cite them, and it should be tested by the High Court and the Supreme Court, and maybe practice directions will come one day.
Thank you. Thank you for that answer, sir. So, ladies and gentlemen, now I request seasoned lawyer Mr. Ranjit Malhotra to give a vote of thanks with regard to the subject matter we have discussed with the legal luminaries here, our distinguished panelists here today. Over to you, Mr. Malhotra.
Thank you so much for your robust comparing. I disagree with the word season. I think that's fiction. I think Justice Sikri has left, and I've been assigned this solemn duty to express profound gratitude. All our well-wishers, esteemed panelists who have been associated with us. They have tolerated us for a very, very long time. I was thinking in the beginning, it's like Club 40 or Club 50. Justice Sikri's left. 10 years ago, whenever I will not talk about law anymore, I will just take 3 minutes. I will not take more time. I can take more time because there is no good food and no good dinner waiting as it used to happen at India International Center in the pre-COVID era. 10 years ago, until 10 years ago, when Mr. Soli Sramji was coming to Chandigarh and when late Mr. Sibal was alive. So whenever Anil drove down this Mr. Surabji to Mr. Sibbal's place for a drink in the evening. They had a deal. They talked only about Lahore and no more. Justice Sikri has been very closely associated with our academic journey. He has always lent us a big supporting hand. He's not here. We would express our gratitude to him in person. And what can I say? Respected, legendary Mr. R.S. Chima. He has given us strong umbrella protection for 40 years only. He is always the same mature voice to whom Anil always relies upon. Coming to Dr. Balram Gupta, he has taught judges, lawyers, generations by scores and dozens. Whenever he goes to any gathering, he gets mobbed by young lawyers right up to judges who may be well into their 70s and 80s. And Deshmukh ma'am, she has so much wealth of experience behind her. It is always a great pleasure to interact with her whenever we are visiting Bombay or whenever we speak to her. She said, a very nice caveat, 142 is going very slow. Ma'am, what I could gather was it's like somebody driving a Ferrari at the speed of 60 on Marine Drive. That was
Absolutely.
that was the
Absolutely.
convey.
Absolutely.
Then come and Mr. R.I. Singh, he is like a deep, silent river. Very celebrated civil servant, equally celebrated author. Last time when the German ambassador visited Chandigarh, there was a small dinner at our home. I requested Mr. R.I. Singh to gift his book on the Punjab situation to the German ambassador. He especially acknowledged the gifting of the book, which he read very, very carefully. He absorbed it. He processed it. I would be failing in my duty if I do not acknowledge all the hard work done by the publishers. I'm sure Anil must have driven him over the wall day in and day out. But then he got used to it. And finally, we are so impressed by our young, dynamic, energetic, robust compere. We now feel, looking back 20, 30 years point in time, it is time for us to pass on the baton to us. Anil and myself were exceptionally fortunate to have worked with very eminent people like Mr. Solis Rabji, late Ram Nivas, respected Midhaji, who always believed in passing on the baton to the younger generation. So we now see that kind of energy in you, which we had 20 years ago. I think I will now stop. We have consumed one entire evening. Thank you so much, everybody.
An evening, sir, of the wisdom.
I would, as a parting note, say, as Mr. Chima would say, Alvida, hum phir milenge.
Yeah.